This is the current federal tax developments for the week of July the 23rd, 2018, brought to you by Kaplan Professional Education and your State Society of CPAs. I'm Ed Zollers, broadcasting this week from a hotel in Tarrytown, New York, of all things. So I apologize if we run into any sort of glitches on today's broadcast, or any sound glitches or other issues, because it's always interesting using a hotel's internet system, but we'll cross our fingers, hope for the best. This week, we're going to look at a few things happening. We're going to look at two state Supreme Courts that restricted their state's abilities to tax trust. We're starting to see a little bit of a line here. We're also going to take a look at an IRS program manager technical advice that looks at what's willfulness for the FBAR penalty. We're going to talk about the fact that the IRS issued regulations this week, final regulations, that allow us to use contributions, actually use forfeitures to fund QMACs and QNECs for 401ks. We're going to talk about the IRS discusses the impact in another program manager technical advice of the impact on taxable wages when you have a payroll tax exam. We'll discuss something that's gotten a lot of coverage in the general press, which is the fact that beginning on 2018 Form 990s, many exempt organizations will no longer have to file Schedule B with contributor information. We'll also talk about proposed regulations that were issued on the due diligence rules that were expanded in the Tax Cuts and Jobs Act to cover the head of household filing status on preparers. Getting ourselves started this week, let's go first to those state Supreme Court cases. Now, as we all know, we've had lots of issues come up recently about the states in regard to the Wayfair decision and sales taxes, but a little more interesting things have happened recently in the area of trusts. We have the case of the Kimberly Rice Kasner 1992 Family Trust versus Department of Revenue from the North Carolina Supreme Court. That case came down in June. And this past week, we had the case of Fielding versus the Commissioner of Revenue. That came down from the Minnesota Supreme Court on the 18th of July. So these are both interesting cases. What they're looking at is under what conditions can a state impose its taxes on a trust. Now, this is kind of a complex area because, to be totally honest, and I teach courses in this area, when a state claims a right to tax a trust, and we're talking about, in these cases, the state's rights to tax all income of the trust, there is no question that a state can tax a trust on income that is sourced to that state. So if your trust has, let's say, a rental property in Ohio, there's no question Ohio can tax the income from that rental property. Similarly, if it's got a farm in Minnesota, that farm's generating income, Minnesota can impose its tax on that income. But here's the interesting question. Under what conditions can that trust with the farm in Minnesota and the rental in Ohio, under what conditions can Minnesota reach out and tax the income on that Ohio rental? And that's kind of what we're looking at here. Also, broader question, since most of our trusts don't have that type of income, but may have dividends, interest, capital gains, when can he get at that sort of income that most often is not directly sourced to a particular state? A lot of states use the idea of looking at where the grantor was resident when the trust became irrevocable. We see that in a number of states. Now, that's not consistent. There are states that use other rules. My home state of Arizona, if there is an Arizona trustee, then Arizona claims the right to tax all of that trust's income and treat it as taxable to the state of Arizona because they're going to treat it as an Arizona resident trust. But that's a minority view. Now, as we're going to discover with the rulings we're seeing here, maybe that minority view is what the states are going to have to adopt in order to be able to tax the income. Because let's talk about this. In the case, in the Fielding case, which was the case before the Minnesota Supreme Court, the one that came up this week, Minnesota is one of those states that now, since 1996 actually, has claimed the right to be able to tax income of a trust if the trust was, if the grantor was a resident of Minnesota on the day when the trust became irrevocable. That was the case here with the Fielding Trust. The Fielding, in this case, not Fielding Trust, but the trust involved in Fielding. In that case, the grantor was a resident of Minnesota. The trust became irrevocable. Now, the hitch becomes that this trust owned shares in an S corporation that operated in Minnesota, and it owned other assets. it eventually sold the shares in that S corporation, generating a gain on sale of securities. The question becomes now, can Minnesota get not just the flow-through income from the S corporation shares, which was Minnesota sourced, it operated in Minnesota, but can they actually tax the other items? The trust claimed that answer should be no. Why? Well, the trustee was not a resident of Minnesota. The trustee was a resident of Texas. The trust itself owned no assets in Minnesota. The trust didn't do anything in Minnesota. The SES Corporation did, and yes, the grantor did, but the trust said neither one of those is the taxpayer. The Minnesota Department of Revenue said, no, guys, that's wrong. First thing is, of course, our law says the grantor, by establishing the trust in Minnesota when he was a Minnesota resident, consented, shall we say, to Minnesota taxing it. Also, the trust was drafted under Minnesota law. And, basically, it's still got that S corporation operating in Minnesota. So we think it should still be able to be taxed by Minnesota. The question is coming down to a constitutional question. And it's kind of interesting because when we discussed the Wayfair case, we discussed specifically the issue that, the Supreme Court had said, look, there is both a due process question and there is a Commerce Clause question. These cases, and this is true of this case, the North Carolina case, are both considered to be due process questions. That is, does the trust have sufficient minimum contacts with the state? The basic test we have for due process on taxes is, are there sufficient contacts with the state to justify the state imposing its tax? The idea being, if there's not sufficient contact, it's not reasonable for the trust to assume there would be such a tax. And because of that, they're denied due process of the law. The state is stepping in a case where the state should have no right to step in. The trust, of course, claimed that essentially, there are no such links anymore. Minnesota argued, oh, yes, there are. Well, in this case, the state of Minnesota, right, specifically said that we don't necessarily buy this concept, is what the Court of Minnesota is saying. They said, first, the grantor's connections to Minnesota aren't relevant. The grantor is not the taxpayer. The trust is recognized for tax purposes as a separate taxpayer. Being its own legal entity, it therefore, should not be tied to the actions of either the grantor or this kind of extends to even the beneficiaries of the trust, right? In essence, you cannot essentially assign the activity of those entities, which are themselves separate taxable entities, to the trust. It also said, look, there's not really Minnesota property held directly by the trust. The trust holds stock, the trust holds other assets, but the trust itself owns no property in Minnesota. And again, the S corporation is a separate company. The corporation's a separate entity. The fact the corporation may own assets in Minnesota does not impact or does not assign itself to the trust. And it said, and the other problem is it doesn't, and also Minnesota cannot use the fact that in previous years, this trust may have been tied to Minnesota. Actions taken in previous years, including the fact that the grantor was a Minnesota resident when he set up the trust, also do not justify Minnesota stepping in. It also doesn't matter that the trust claims to be drafted under Minnesota law. Now, in this case, they made an interesting distinction. They said, look, anybody can choose to use Minnesota law. And, Minnesota Department of Revenue was pointing to certain cases saying, well, these states that established trusts, these trusts were taxable, and we have all these due process. And we had these in both Minnesota and other states where we said, well, that doesn't have any problem with due process. And, well, that's different because there the probate courts were involved in setting up the trust. So Minnesota courts were already involved. In this case, unless something happens, and unless the action properly could be heard in Minnesota courts have no activity here. Merely using Minnesota law to say that should be the law under which you interpret your trust does not give Minnesota the right. So the Minnesota Supreme Court said, guys, Minnesota has no right to tax this trust. Now, the trust argued a bit broader. They claimed that because the state only claimed a right to tax based on where the grantor was, that effectively no trust should be a Minnesota resident trust and taxable with all income taxable in Minnesota, because the state is only allowed to use that one area. The court denied that claim. The court said, no, no, no. Here's how the rule works. First, we test to see, does the trust have sufficient connections? We don't care what Minnesota uses as its test. Are there sufficient connections to allow Minnesota to tax it? If there are, then Minnesota can then tell us the conditions under which they would tax it. And that's where we look at, was the grantor resident Minnesota? So again, two tests. First, are there enough minimum contacts? If there are, then secondly, was the grantor Minnesota resident when the trust became irrevocable? If both of those are true, Minnesota can tax it. If not, Minnesota can only tax Minnesota source income. Now, the North Carolina case, the Kimberly Rice Kaestner Trust, and I'm sure I'm mispronouncing the family name there, and I apologize to the family if somehow they're listening. That particular case, there, North Carolina claimed the right to tax income on a trust where income was being basically earned in the trust, eventually for the benefit of a North Carolina beneficiary. But in this case, the beneficiaries did not receive any distributions from the trust, and they had no right to force any distributions from the trust. North Carolina courts, using essentially the same logic as Minnesota, but this was back in June, so this is a court using the same logic, says, look, you cannot assign, in essence, sufficient contacts, and again, it's the same nexus test, based upon the rights or based upon activities of another taxpayer, in this case, the beneficiary. Therefore, the North Carolina court ruled as well. Sorry, North Carolina, the trust itself does not have sufficient contacts in North Carolina. The fact that its beneficiaries, who are separate taxpayers in and of themselves, have contacts with North Carolina does not make it into a North Carolina trust. Now, as I said, this is kind of interesting because we're now seeing two separate cases where the state's taxing abilities on trust are being nailed by essentially being nailed by the state Supreme Courts based on constitutional issues that are due process issues. Remember, when we're talking about Wayfair, we're talking about dormant commerce clause issues, because under Wayfair, it's pretty clear, and I think that's probably true for most of us, that there's not going to be a due process issue if you're actively selling into a state. If you're selling into a state, then you can reasonably expect you might be subject to tax, so the due process falls away. Trust, the courts are now much more inclined to accept the due process argument. And the due process argument is how the trusts are losing. It'll be interesting to see if this pattern expands. We've seen this idea before, but now we're starting to see a bit of a pattern on it. So it's interesting to see this happen. Certainly keep your eyes open as to what happens with trusts in this area. Let's go on now to an IRS Program Manager Technical Advice, 2018-013, issued on May the 23rd of 2018. This raises the question about the Foreign Bank Account Reporting, FBAR, the FBAR reporting form. And the question becomes, as we know, there are two levels of penalties. You can have a level of penalty for just simply failing to file. That's the $10,000 penalty. Or you can have a penalty that is much higher imposed if you willfully refuse to file. Now, as we discussed earlier this year, what that penalty is now subject to a bit of a dispute as to where the IRS is bound by their old regulations. But it's still significantly higher. It's still 10 times higher is the maximum penalty, certainly goes up to at least that. So it's definitely a nastier penalty. The question is, when are you willful? And what this does is the Program Manager Technical Advice, and we've discussed previously that the courts have allowed this, that we're going to take a look at what makes something willful. Now, obviously, if I know I should file the FBAR form and I don't file it, I know it's required, and I say, you know what? I bet the IRS will never find out about this. I'm not going to report the income from this foreign account, and I'm certainly not filing the FBAR report. If I do that, the question becomes, obviously, that's willful. But does it really have to be that kind of a knowing, absolutely knowing for sure I am required to file in this case? There's no question that's true. Is that what the IRS has to show willfulness? And the IRS says no. And we've discussed cases before that come down this. Willfulness is not limited to showing that you knew you had to file and you didn't. Rather, did you recklessly disregard your filing responsibilities? That is, did you know, look, having an account offshore of $2 million that's generating, $100,000 of income every year, are you willfully failing to report that? Might it occur to you that there might be a reporting responsibility for that? When you have this big asset offshore, aren't there some things you might be concerned about how you report that? And the IRS says, well, guys, yeah, I don't need to show you know it has to be done. And one of the key things that is often used and has been used in the cases is that question at the bottom of Schedule B. It doesn't say you have to file necessarily, but it does put you on warning that the IRS is involved in this. And of course, people are reporting income on Schedule B. So we have these issues. If you in fact do this, so reckless conduct, which includes being willfully blind, failing to seek advice about whether there is a reporting obligation, failing to investigate on your own whether there's a reporting obligation, that conduct constitutes willful blindness. The courts have definitely gone along with this view. This PMTA is really just stating what the IRS has already basically been able to sustain with charges in the court. Realize if your clients are not, clients can't just say, I didn't know, or I didn't want to ask my CPA about this issue. Rather, they have to understand that this is not just simply not knowing for sure you have to file. Rather, if you have any reason to believe or any reason to suspect that maybe you should be filing, then you have a responsibility to kind of check that out. And that's where the problems have come. So again, that's the issue on the technical advice. Now let's move on to some final regulations we got this week. This is Treasury Decision 9835 issued on July 20th. And this deals with the requirements for qualified matching contributions and qualified non-electing contributions for employer retirement plans, generally for 401ks. If you do a 401k, you know that unless you're using a safe harbor plan, you have to meet the average deferral percentage or the average contribution percentage test every year, or the highly compensated are going to end up getting refunds, having to take money back out of the 401k, not able to defer what they want. One of the ways you can totally or partially fix it, depending upon your situation, is to use these things called qualified matching contributions or qualified non-elective contributions to the plan. In essence, and QNECs are quite often used, where these things, in essence, the employer after the fact throws more money at the plan. That money goes to the non-highly compensated to get their numbers up to where we need them to be, so they come in line with the highly compensated to get us into the proper location. Now, generally, under either the ADP or the ACP test, and that's what the average deferral percentage, average contribution percentage test. Generally, the rule is if the non-highly compensated percentage under either test is 2% or less, then the highly compensated can basically have no more than twice that percentage. So the non-highly compensated aren't putting much of anything in, then we greatly restrict the highly compensated. If the non-highly compensated or their percentages between 2 and 8%, then the highly compensated can contribute no more than what the non-highly comps do plus 2%. And finally, if the non-highly compensated percentage is more than 8%, then the highly compensated percentage has to be the non-highly compensated percentage times 1.25. Basically, they can put a quarter more in. A quarter more can go to their account or can be put in, depending upon which test we're looking at. Now, the catch is, so we put this money in to bolster the non-highly compensated. But these contributions had to meet requirements that say that these have to be non-forfeitable. There are various other requirements about these things that are done. And under the regulations that existed prior to this week, they had to, the money that went in had to meet those requirements at the time of contribution to the plan. Commentators had suggested, well, here's the catch. A lot of these plans have forfeitures. Forfeitures are where we have had, let's say, employer money went into the plan and got allocated to participants' accounts, but those participants did not stay around long enough to vest. So a portion of the employer contribution, now never the deferral of the employees because that has to be fully vested from day one, but a portion of that fund that did not have to be fully vested immediately goes into a pool, and that pool can be used for various purposes. Those purposes include it can pay for, I'll get it stated correctly here, plan expenses. It also could be used to be allocated to participants. There are various things we can do. They said, we really should be able to use those forfeitures to handle QMACs or QNECs. But the problem is we can't, because at the time those funds were contributed, by definition, because they were forfeited, they weren't non-forfeitable. So, realistically, the point of the QMAC or QNEX is to give a non-forfeitable amount to the people that are there today. So there seems to be, since forfeitures, the money's fungible, forfeitures are, it's money, it's, I shouldn't say money, it's the account balances, just like, a contribution would be. Shouldn't we really test not at the time of contribution, but at the time we allocate to the account? So the question was, can we switch it? The regulation says, that's actually right. There's no reason why forfeitures should not be allowed to be used to be QMACs or QNECs. So we're going to allow your plan to have this change and allow you to use forfeitures to satisfy some or all of any QMAC or QNEC payments that are made. This will, of course, allow us to fund that money without having to take new money and throw it into the plan. Now, one question was raised that this was put out as proposed regs, and really the proposed regs that were issued back in January of 2017 were not really changed by these final regulations. But people said, but wait, here's the problem. If our plan currently allows for these forfeitures to be used for contributions to employees, aren't we in violation here of 411D6? Because under 411D6, we essentially can't amend a plan to remove an already vested benefit. And, let's say, these people already have enough hours this year. They're going to get a benefit. Isn't it a problem using 411D6 at this point? And the IRS said, okay, there actually are two ways to look at this. Number one, because yes, you do have to amend your plan to allow the forfeitures to be used this, and your plan doesn't currently allow for it, so we're going to amend it. They said first, obviously, you could amend the plan today, and as long as it doesn't take effect until the following plan year, you have no problem. So there's solution one. They said solution two, though. They said many plans allow forfeitures to first be used to offset plan expenses. And then after plan expenses are paid with forfeitures, then we go ahead and allocate those to employee accounts. They're saying if your plan says that, then really there is not yet any vested benefit because the benefit doesn't exist until we know what all plan expenses for the year are. They said if your plan is that way, then you actually can amend your plan today and have it apply for the current plan year. So if that's your structure, it's fine. These regs apply for plan years in this case, right? Our applications, will apply for plan years that are ending after July 20th of 2018. We also allow it to be used, I should say, for plan years beginning after that date, but you also can use it for earlier years. That's interesting aside too. So basically, yeah, you're open to amend your plans right now to come under these rules. Do you want to? Well, I think a lot of employers who are having to make these contributions probably will want to make this amendment to the plan. Obviously, it's something you want to discuss, have your clients discuss with their plan advisors and wherever they are getting their plan documents from to see about whether they want to go down the amendment route and try to get this done to be able to make these payments out of forfeitures. Next up, another Program Manager Technical Advice 2018-015 issued on June 25th of this year. Now, this is a payroll tax exam, and it's an interesting advice in this case. And at the end of this payroll tax exam, we find $10,000 of fringe benefits that should have been taxable to an employee. Now, based on that, the employer should have withheld FICA, and they should have withheld income taxes from the 10 grand. Now, interesting aside, and the employee obviously didn't report that as income. So that defense of the payroll tax is kind of done. We can't go there. So the bottom line is, how does that affect things though? So under the example in question, these particular payments were made in, shall we say, these payments were made, let's see. You performed in 2018 an examination of their 941s for 16. So in 2016, there was this 10 grand of fringe benefits that are taxable. We're finishing the exam in 18. Now, the first question is generally, if the taxes weren't withheld, the income taxes weren't withheld, we would have to go back and pay the withholding. It should have been paid. This being a bonus in 2016, it would have been 25%. So we would have to pay the $2,500. Now, the IRS agent was saying, but wait, isn't that $2,500 additional income to the employee? Because essentially that's tax, and it should have come out of the 10 grand, but we're now paying it on our own. So shouldn't we have to gross up the 10 grand before actually paying the tax? Now, that's an interesting problem, because if we do, that's going to raise our tax from $2,500 to more than $2,500, because now we have to get to the point where that $10,000 is 75% of what should have been there. So that's going to basically add $3,333 to the wages and increase the amount to be withheld to $3,333. The IRS said, and then the second question is, and what about the FICA? Don't we have to do something with that? And the IRS says, okay, here's the catch. The IRS is not allowed to gross up that federal withholding tax. So $2,500 is the proper number. However, that $10,000 is taxable to the employee back in 2016. And the employee really does owe the tax in 16 on that 10 grand. If the employee actually pays the tax, files the amended return, pays the tax, then the employer can get a credit against the $2,500 for the amount that the employee pays. However, big caveat, the employer cannot go get the $2,500 from the employee. The law does not allow him to do, him or her, whoever the employer is, him, her, it, to do that. Rather, the employer has to eat that difference and only can get a credit if they can show the employee pays the tax. But what about the FICA? I mean, the FICA was the same thing, isn't it? Not really. FICA under the law is still owed by the employee when it's not withheld. So in this case, the employer has a right to collect it in 18. If the employer does not collect it in 18, then in that year, and that year only, they end up having to collect extra tax. Now on to Revenue Procedure 2018-38, issued on July 13th. This is something, actually, it's very simple to explain, and you can then go to the press and go over what all this thing means. But non-501c3 tax exempts will no longer have to file Schedule Bs that report their contributions by major contributors beginning with the 18 returns, right? They do have to still maintain the information, and if the IRS requests it, they have to provide it. And it is effective for 18. So if you're still filing, if you're on extension and you're going to be filing the 2017 990s, you still must provide that information on Schedule B. Now, as I said, this has become a political hot potato, but for today's, and for as far as I'm concerned, for our discussions in this realm, and in a course I would teach, so, don't bring this up either. The issue here is just what's the filing requirement. The requirement now no longer requires a Schedule B. If you want to discuss politics, well, there's lots of venues for that, and you can go down that route. But in this case, just remember your non-501c3 organizations will no longer need to have the Schedule B for large contributors, but they still have to maintain that information on request. And, that's still going to be a requirement if the IRS examines you. That doesn't get you out of any of the requirements or any of the rules related to these people. It just gets you out of the reporting. Now let's talk about IRS Regulation 103-474-18. This is a proposed regulation issued on July the 13th, and this deals with a Tax Cuts and Jobs Act addition of a brand new rule. The Tax Cuts and Jobs Act added a brand new category to the due diligence rules for preparers. Now, and I know people hate that checklist, right? You remember that the nice little form you file every year. When this happens, remember, we have to prove that the taxpayer has a right. We have to have a documentation that the taxpayer has the right to claim various credits. It may be the earned income credit, it was a child tax credit, it was the American Opportunity Credit, it was the additional child tax credit. Now, that same requirement is going to apply to us to properly document and have in our files information supporting the taxpayer's claim to have a right to be head of household. So what the law said, it added that this regulation merely expands the existing reg to cover the law that Congress added, saying that you absolutely must have this issue. Therefore, you have to have inquiries and or evidence to support the taxpayer's claim of right to claim the child. As was true with the child tax credit, one of the big issues we're going to run into is, do they have an actual right to the exemption this year? Did they have, did the child live with them? What evidence do they have? Do they understand the rules? This is, again, one of those issues that's set up to decide either we penalize you or we penalize the client. Did the client do that? We find this is a major problem with divorced taxpayers, where the parties start disputing. Each one wants to be head of household, right? They each claim the client, the child lived with them or was with them more nights during the year. You need to ask them specifically, explain the nights rule. Ask them specifically, do they meet that requirement? Did they also provide over 1/2 of the cost of maintaining the household? Because they have to show that as well. If, for instance, let's say, this particular person who wants to claim head of household status is living with someone else, and that someone else is really providing the cost of the household, then we might have a problem. So we need to worry about all of those issues. If you do not have that information in your files and the IRS basically discovers that your client should not have been head of household, you are subject to an over $500 penalty. As the regulations point out, that will be in addition to the child tax credit penalty and potentially the earned income tax credit penalty and the additional tax. We got all kinds of penalties that could pile on in this situation if you just go ahead and file them as head of household. You need to make very sure your entire staff is told that you can't just assume they qualify for head of household. You need to make sure that you at the very minimum have explained to the client the rules for head of household, explain to the client what it means to support a household, what it means, what they have to do to be able to claim an exemption for the child. The fact is, their divorce decree itself is not good enough. They've got to be able, if they're claiming custodial parent, they've got to show over half the nights. By the way, that's a key distinction. The fact that the state of, let's say, Arizona may award them custody does not mean they are the federal custodial parent. We don't care about who was awarded. We care about where the child was under federal law. And so if, in fact, they were awarded custody, but their ex actually kept the child more nights that year because, for whatever reason, they allowed the child to stay with their ex, that's a problem. I don't care they were awarded custody. That's not the issue. So be very, very careful of properly documenting this. This is, again, an addition to our checklist for this year. Well, as always, we want to remind you, these sessions are brought to you by your state societies of CPAs and by Kaplan Professional Education. Check your live state society course offerings in their catalogs at this point. We have lots of those coming up. Going to be doing various sessions all around the country. So again, whatever's coming up, be sure to check that out and, take a look at those. We do them live. A lot of the states are also offering their courses as webinars. So we have those. I do want to remind those of you in Idaho that I will be coming up. I will be actually not coming up, but I will be doing a webcast on August the 3rd for Farming and Ranching Businesses and Tax Cuts and Jobs Act, August 3rd, 4 hours. There we're going to look at the issues that impact agriculture, including that really weird 199 Cap A issue as to how you integrate basically the issues that we have here on 199 Cap A when we look at the cooperative 9% issue and how that works with the 20% for the farming operation itself, and also how you can end up with an 11% potential theoretical benefit only if you're selling to a cooperative. So we'll take a look at kind of those issues. Those informations are at information on signing up for this, www.idcpa.org. Again, this has been The current federal tax developments for this week. Our regular updates are on the website, currentfederaltaxdevelopments.com. You can find us as we post information there. If you have questions or comments, send them to me, Ed Zollers at currentfederaltaxdevelopments.com. You can follow me on Twitter. There I'm at Ed Zollers. And you also can follow discussions on the subreddit at reddit.com/r/taxpros. I also monitor a couple of state society discussion groups that I'm allowed to come into. So if you have any questions, you can take a look there and I'll answer. I'll try to keep an eye open for things there if you have questions for me. And the advantage of doing it in these open forums is that we can help a lot of people, by discussing issues out there and finding things. And again, I'm hoping that this week's broadcast went without too many hitches. Again, being on the road. Next week, I'll be back in Phoenix, so I'll be broadcasting from my normal location with the normal connections that I have. So we look forward. Obviously, there's more happening. I've already got some material ready for next week, believe it or not. We just had so much this week that I decided I was going to leave a couple things for next. So we've already got things going. Look forward to talking to you next week. We'll again look at what's happening here in the area of federal tax developments.